where were we?
Hearing officers, page 1.
Do you want to go to page 1?
Yeah.
Go ahead.
I know we still have on the table the question of 4 to 6 years and the question of appointments. And if, I think we should address that. I just wanted to flag another issue, if I may. On page 11, page 1, line 11 and 12. I think we can make this a little more clear by indicating, I appreciate the expertise and skills. I think that's essential to ensure that we have a well-functioning board. And I appreciate having a board with expertise. And may I offer a slight modification to reflect fundamentally what we're looking for. Environmental science, natural resource law and policy, land use planning. I actually would appreciate combining or thinking about, instead of land use planning, community development, turn that into community planning and say environmental justice or racial equity. And I think that way we have 4 categories and clarity as to the type of expertise we're seeking. So it would read environmental science, natural resource law and policy, community planning, and environmental justice or racial equity.
And
Yeah, I don't think it would be and, be or.
they're all.
Or, yeah.
Jim.
I think land use planning and community development can be distinctly different categories. And I see no harm in keeping them separate. And land use planning can go to forest blocks and connectivity, which has absolutely nothing to do with community development. So, I mean, that's just so I like the way it read, but I don't like the underlying thought.
Well, if I can clarify, I think the planning experience is critical. Land use planning, community planning then. But I think that is fundamental to what Act 250 is and the value of Act 250 and what it provides for us. And I think that provides clarity in terms of the skill set we're seeking.
Can't plan too much. I'd welcome the additional word of planning in there for sure. After community.
I don't like the idea of striking out land use, just because this is the #1 land use regulatory law in the state, and I hate to use it. I think it has to be there. We have to have land use in there somewhere.
So my modified change, based on comments, are to read environmental science, comma, natural resource law and policy, comma, land use planning, comma, community planning, comma, or environmental justice and racial equity.
Better.
Okay, I just keep going.
You're going to keep going?
Yeah.
We can, go ahead now.
So, community development. What if? Does that mean developer? What is experience in community development mean? Does that mean that somebody who has experience in actually building the, the actual process of building the community, or is that is that actually trying to get to somebody who has experience in planning a community?
Can we go to just what people want for qualification?
Sure.
Because unless someone, I don't know that it's helpful.
Well, I'm wondering, why just add community planning, then you keep community development, what's the difference? I don't see what the
Community
difference
planning and
is.
development are the same to me, but.
Okay. It might not be the same to me.
Wow.
I might have a construction background, it might not be the same to me. Like if I, say I was hired to build a community, I didn't plan it, somebody just said, you know, let's go do this, and we have to build it, you know, to withstand natural. And so say, oh, okay, and so just add. Why don't we just add community planning instead of striking development?
That's what I'm wondering. Can you
Strike
really
development,
be clear
add
about
planning, is that
why?
what you?
No, it's not. I keep them both.
Keep 'em both.
Because they could be different in my mind.
Yeah.
You don't wanna rule out the
We could-
contractor?
Are you worried?
One's
What are you
planning,
worried
one's doing
about?
it.
Right, right.
You gotta just say what you're worried about.
One's the idea,
Sorry.
one's the process of doing it. In my mind. You know, technically, you know, we may be spending too much time on
I
this.
think we are.
But, you know, you are worried, so can you just say
Well,
what your
look,
worry is?
my concern is that whether we aren't getting the full suite of skill sets per board. And I want to make sure that we're helping to prioritize the suite of skill sets. We're not necessarily just getting, for example, developers on the board, that we're getting. Yeah, we're getting people who are recognizing that development is important in the context of community planning, in the context of land use planning, and in the context of our environment pertaining to that landscape, the very landscape features where Act 250 is targeting.
So you
and-
want
and-
developer out.
So that's
You don't
why I
want a
think that,
developer on.
this is a, as you mentioned, a consummate planning, a land use planning law in the state of, on our books. And let's ensure that the appointments are, attracting the right candidates.
Okay. I think there's merit to that because the other members, these are the long-term, holding the statewide vision for land use regulation in the state of Vermont. And other members are gonna join in that, from the district commissions through a different appointment process. So, anyway, we are spending too much time on this. How do folks feel about exchanging community planning for community development? That's what I'm hearing is on the table.
The other way around. Replacing community development with community planning.
Yes.
That's fine. I don't. It doesn't matter. It doesn't matter. It's
Okay,
fine.
let's move on. Let's try to go, high level. We were talking about hearing officers, that's Ellen reminded us. And trying to imagine how this is gonna play out in the field.
And we're not gonna resolve the retention, or,
Okay,
I
retention
mean,
is
that's
next.
on page 1.
You want me
So I think it's important just to have an appreciation. So the judicial retention process, generally speaking, judges are appointed for life subject to a retention by the General Assembly. So if you were going to mirror that process, those terms never end of a judge. They're subject to the legislature ending them, but not to sort of a term of years like I think is contemplated here. So just putting that out there for the committee to understand at least briefly how the process works.
They're subject to a certain time and period to be, have that retention hearing, are they not?
They are, but the term of a judge, absent the legislature voting not to retain them, is indefinite.
Okay.
Okay. And so right now, we are deciding really not about the original nomination. Do we agree on an original nomination process to be like, in the manner of a superior judge? Okay. So it's the reappointment that we're wondering about. Let's just say, how are people feeling about 4 years versus 6 years?
The possibility, if it's a professional board full-time, what about the possibility of indefinite? Makes sense at all, like the judges. They're longer than there, the experience that they have, they're full-time, it's a profession, a job for them. They just go on until
So the
we
only
don't want them to go on.
and the only way they could leave would be to retire, or the legislature would say
Legislative
no.
I don't like that much.
Just a thought.
All right, so this, Tim?
So the question I heard, do we like 6 years best or 4 years
Yes.
best? And I like 4 years best.
Yeah,
We just want to do a straw poll.
yeah. All right, who supports 4 years?
I would go with
2, 3, 4, 5, 6. 6 years.
You're voting for it.
You can vote 3 times if you want.
We're gonna go 4 years and move on to reappointment. Remember wishing to
Page 2,
succeed?
line 13.
Succeed, that is so awkward.
It is,
I'm
isn't it?
sorry, lawyers sometimes, remember wishing to succeed himself or herself? Follow yourself.
You can just, you can serve for more than the 4 years.
I know, but-
Yeah.
Yeah.
In office may be seek reappointment under the terms of this section, so
Can you just say a member
yes.
may seek reappointment?
Yeah, I think you could. So, under the terms of this section, and what does that mean as it's currently written?
They have to go through
The whole process again.
yeah. But whole process being they put their names in with the judicial nominating board. The board evaluates their qualifications and the name goes to the governor if the board thinks they are still qualified.
And it comes back to the legislature.
Yes.
Senate, yeah.
Senate.
To the Senate. Okay. I'm fine with that. Okay,
Yeah. I'm good.
let's move on.
Voting.
No, Senate.
Page 3. Gary.
I would just like to flag what we had already talked about, to make sure we added that qualifying language that Counsel Chapman had described. Line 15 perhaps.
I guess I would just add that I don't think that minor applications generally require the assistance of outside experts. And so I'm not sure what this language is really doing.
Yeah, I think when we discussed that there may be, with the additional criteria and with pre-application meetings, there may be some trainings and assistance that we haven't foreseen. And
Yes.
this at least provides, ensures that the resources are there so that they can function adequately.
So, yes, and I'll say one of the reasons I'm supporting this proposal is because of the need for the board to be strengthened and support our district commissions better through training, and because we're adding criteria, and I expect those are gonna be, they're gonna require rulemaking by the board, not district commissions. And this is, like, we don't need separate, each district commission going off and having trainings for themselves, or, I don't see how that is related. The board getting stronger is, in my mind, intended to support district commissions and the whole system getting up to speed on new criteria.
I think what the suggested language that we heard from Counsel Chapman was to say that the board shall ensure that there are resources necessary to enable the district commissions to perform jobs, including training. I think that was, but it, for the very same reasons you had mentioned, that we want to make sure that those decisions do happen at the board level.
So we're gonna keep may authorize and add that supporting language.
Yep.
Okay, moving on. Questions on the next page?
Wait, I'm sorry, can we pause? The line, personnel employed by the district commission shall not report to the board?
What-
That's on line 13 to 15. Is that gonna come out? Cause that's sort of in conflict with the idea of strengthening the board, that's,
I don't know if that, are there personnel district commission level?
Well, it's
What?
authorizing
This is
them
right, so
since
it's-
before.
Right.
Yeah.
Yeah.
See,
Right, so this is part of the old proposal that is disparate with yours a bit, right? It's the option of strengthening the board versus strengthening independent district commissions. So I think if you're attempting to strengthen the board, you may wanna take that out.
Yeah.
Good
That's
catch.
fine.
Good catch.
Okay. Next page, I had a question about line 17, the on page 4. Governor may appoint not more than 4 alternate members from the district. I was, right now, that's how it is, and it's not necessarily happening. But I didn't realize it was a may appoint not more than 4, but I think it, I don't know if it matters. But it seems like a lot, 4 more for a three-member district commission.
I think there's 2 issues there.
Yeah.
One is shall or may, and I understand this is existing language, but we've heard the board has not been, and then we've heard, well, we're having a hard time finding people with a, but there's no jail if you can't find them. But if we say, you shall do this, that's more direction. Some have said the board hasn't worked very hard to find members and is thereby then weakening the structure. That's assertion's been made to me. I don't know if it's been made in testimony.
I've heard it.
So I like that, and yes, too many alternates. We're having trouble finding just 3 people. Getting 4 alternates for 3 people is like, what?
Yeah.
You could cut the alternates in half, I would think, from that language.
Okay.
Can we turn that into a positive?
Yeah.
They appoint up to 2?
Matt?
May I ask, Evan, if has there ever been? Is Evan still here? So he's left the building, huh? Well, I was just kind of curious about have they ever had a need? Like, has so many people been disqualified from the process that they needed before? Has that ever happened?
Well, what I've heard from him is that if that were the case, they would go to another district commission.
Oh, okay. Oh, okay.
They share among, and we've heard that that could be helpful for some cross-pollination.
Sure.
I'm thinking about a big district needing maybe more alternates than a smaller district, so you don't wanna prevent that from.
Okay. I mean, maybe it's fine, but we do need to, we did add language that the governor will ensure appointments are made in a timely manner.
We did.
Is the chair always on a 2-year term in this scenario?
Yes.
Really?
I don't think that's helpful.
Yeah.
I think they should just be 3-year terms. Well, like, 2 members, oh, I guess they're 4, sorry.
Yeah.
I think they should all be 4-year terms.
Yeah.
Okay.
And then it's consistent with the board.
That's a good one.
Yep.
Amanda, ask a question. We also heard from a witness that they were reappointed, but only for 1 year, and I don't know if that was because they only had 1 year left, or whether it was a truncated term. So I'm hopeful that the language that we have here will ensure that appointments are made timely and that they're made for the entire term that we, and I think we have language shalls in here. Shall be filled for the unexpired period, but shall be appointed for the 4-year term, the full term. So I just wanted to make sure we've solved that issue.
I have no idea what you just said. I think sometimes you get appointed to fill a vacant term,
Right,
Yes.
and
Yep.
that's where you get a one-year term from.
Mhm.
okay. I had heard that it was just a truncated appointment, not for the full term in one case. So I just wanted to,
How is that?
Right.
Okay. Let's go. I have a question about the bottom of page 5. It's come to our attention about the wildlife access to projects for assessing impacts to necessary wildlife habitat. I think we've come down on the side of leaving it. Have we come down on the side of leaving it the way it is? I guess I need to be reminded. For burden of proof.
Yes, I left it intact because your bill and the joint proposal were in agreement.
And so burden of proof is on the applicant?
Yes.
Okay.
For wildlife, yes.
And does 2 though, would 2 allow, who are parties? It's come up for me in another place in this bill too. Like when they decide where to hold their hearing, the affected parties, and then in this case, this allows parties to enter upon lands. If someone did want to enter land to do a wildlife assessment on a proposed development, and they weren't the applicant, they didn't own it, would this enable them to do that? Could the board enable them to do that with this clause here?
That is a good question. So first, parties. There are statutory parties to an application. That includes people who obtain party status. So when you apply for party status, it's because you have a particularized interest and particular criteria related to an application. I do read this language as allowing for that, but I am not certain then why an issue has arisen if this is existing language. So I guess I'm,
Right.
yeah.
Isn't there a site visit that normally goes with a kind of a project where the parties go onto the site where it's going to be based or built?
Not always.
Yeah.
I think they have the option, but
But this is different from a site visit. This is investigating conditions, and I think Matt was nodding that he thinks this does allow it would allow,
I do. I think it allows the board to grant access to an individual to go on to the applicant's property to perform some sort of study. It does require, I think, the party, excuse me, to request that sort of order or access from the board or commission. So it's not automatic.
Jim,
That's resolved, are we good? Because I got a different issue on mine.
I'm good.
Line 11, through 13. It says right now, the board and district commissions shall have supervisory authority in environmental matters respecting projects within their jurisdiction and shall apply their independent judgment in determining facts and interpreting the law. This raises a couple of concerns and a question. If it's the board, right now it reads the board and so the board could say, we got supervisory authority over you guys in all environmental matters. And our independent judgment says, so, and it doesn't, and by the way, you think that's a major, but we think it needs to be You think it's a minor, but we think it needs to be a major. So that's the second issue that may spin out of this paragraph. I think later we have an opportunity to discuss majors versus minors and who hears them. But I think in this paragraph, we're better served to just strike the board and it would read, district commissions have this blah, 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 supervisory authority in their in their district, if you will.
Can we hear what this is addressing?
Right, so this is about, this is existing law that comes from Supreme Court precedent that really affirms the board and the district commission having a supervisory authority over the holistic process, so that when they receive the supplemental or sort of the permits from A&R, they apply their independent judgment. So this is not directly about what you're speaking about. This is existing law that has been in precedent for more than 30 years that is being added to this section to put into statute what is already practiced, so that the districts, the district commissions and the board have the they're supervising in a holistic way the Act 250 process, versus when an A&R permit looks at a very specific element of a project and issue their permit.
I stand down.
Well, I was just gonna recommend that we put each, the board and district commission, each shall have.
I think
So it's each, it's more or less underscores their independence.
I would also just say that this is the language that came out. This is one of the few remaining sections from the commission's report,
yeah,
as recommended.
And I guess even under the current structure, the board does have authority over district commission. So I think we need to remember that as we're talking about this. I don't think anyone's questioned that. And then I think that's, we don't need to create sort of 9 separate entities. We're trying to coordinate and strengthen the whole system.
Yeah, we are.
So let's focus on that. All right, let's keep going. Carol has ideas or concerns about the board records, and I wonder if you have thoughts at the bottom of page 6, I think is where it comes up. Publish or contract to publish annotations and indices in the decision of the environmental division. So right now, Act 250 is no longer going to be appealed at the environmental division. Where, like, how will the public access both decisions of the board, which I guess the answer is probably on their webpage like they do now, NRB board, and then it goes to the Supreme Court. However, much of what's happening in Act 250 is based on past case law, so it'll remain in environmental division, the history, since 2004, 5.
I think we could add, I wrote down that we should probably add Supreme Court to that line. I'm not sure, because this is referring to the e-notes, and so the board in its current, as contemplated by this draft, is issuing permit decisions, and what the e-notes currently contain are appeal decisions. So I don't know if having an index of all of the permit applications necessarily is what you want. I think you want the precedent established by the court. So probably just adding the Supreme Court. I think they do that already, update it with Supreme Court decisions, but.
Matt?
So if you go back and look at the board's webpage, you'll see that they have the historic land use permit on the webpage as well. And basically those land use permits have both findings of fact and conclusions of law, and occasionally they'll issue sort of interim orders that sort of explain how the criteria work or include within the land use permit itself an explanation of criterion 5 or however it was applied in this particular case, and those do actually get sort of folded into the e-notes historically. So you may also want to consider adding board into this list of tribunals.
The board may publish or contract to publish indices of the decisions of the board, the environmental division, and the Supreme Court. Okay. Does that meet your needs, Carol?
Well, I would just, for when you're searching for the precedent, I wonder if it's as accessible. Will it be just as accessible as anything that the Supreme Court is deciding?
Yeah, have you ever used the e-notes? It's a fun thing to play around with. It's 740 pages, and it's by topic. So,
Esoteric lawyer
That's
font.
why you're the
as far as databases go, it's not bad. And I think they do. I think the Supreme Court is already at it now when they have decisions related to those specific topics.
So a regular citizen could,
Yep, it's right on their website, and
don't have to go to a special library anywhere.
Nope. You can open it up, and it's got hot links in it, so you can jump between the different.
Let's keep going. So this, on page 7, it says the board may petition the environmental division for revocation of land use permits. Did we already cover that?
We did it.
Okay.
So we decided that I have to rephrase it because the board is going to conduct revocations, and so I guess so it needs to be changed.
Yeah.
Okay, sorry.
Yep. Striking,
Yeah.
may petition, including ratification.
You got it?
I got it.
All right. Next. We've already made a change on line 10. The board may delegate to the district commissioners authority to determine. Okay. Anything else on this page? Jim?
This is where I'm bringing back the tension between the district commissions. I'm going to say the potential tension, but what I see as a tension, to determine whether an application is a major or minor. And this also fell to a question Paul had. It starts out as a minor, but through the process becomes a major. And so I guess I'm going to say that I don't want the board to reach into my District 4 and say, this is going to be a major. When it happens organically, as Paul said, then it's just going to become a major, and then it goes to the board. And I don't quite know how to write that, but I don't want to cede without some discussion my district or any of the district commission's ability to act on majors if they don't want to. Now, maybe if we do need this, then we need the board in consultation with the district commission.
So it seems like your question is who moderates a disagreement between the board and the district commission on whether something's a major or a minor? How's that decided? And Ellen, yeah, no, go ahead.
Right. It appears that the district commission says they're going to determine whether an application is for a major or minor. That's line 11. It does say they can delegate authority, but it does say hello may again, and they may not delegate that particular authority and hold it in their vest pocket. And I raise that as a policy decision. I understand we're creating a board to deal with majors, and we have two people from our district to deal with them, to work with them. If that's what we're going to do, we ought to just say that, perhaps. But that's
Can I ask a question? So, right now, the more I'm hearing you talk, I'm thinking, so let's say you are a person who wants to go before you want to just cut out the district commission entirely. You just say, I want a hearing, and then you're up to the, is that true?
If you request a hearing, it becomes a major application and it goes to the board.
So now, you could just cut out the district commission regularly if you wanted to.
you asked now,
And
but
not
it's
now,
like now.
well, under this new
Oh, I see.
thing, you don't like the way, you like the way the Natural Resources Board is deciding things, you ask for a hearing, you're out of the district commission.
Well, it's not that you're out of the district commissions, the two district commissioners are participating as part of the
But
board.
they're the minority. Yeah, I'm not
What
arguing
if they
with
weren't
you.
the minority? What if they were the majority?
What if they were?
What if there was a 2-3 the other way?
Well,
Two
no.
or three. We make that four district commissioners.
Because I'm starting to feel anxious as well.
Well, I'm serious about my question. What if it was
Yeah,
2-3?
I'm seriously thinking about it.
Yeah, well, we should seriously think about it. I don't know.
$500,000 a year suddenly got dropped because it'd be two board full-time.
No, I think you'd still have a 3-person board.
Okay.
But 2 of them would come to the region
I see.
to work with 3 district
Okay.
commissions.
They come in and they help.
I mean, I guess my mind keeps going to really what we could be talking about is supporting on the record for major applications, and I mean, you do that by sending the hearing officer. I think that's gonna end up happening anyway, and so why wouldn't we talk about having district commissioners have 3 members?
But just for majors. But right now, I feel as though if we were to do that, then anything that's kind of just a hearing but not necessarily stressed out hearing, we lose the relaxed part if it goes straight to on the record.
Yeah, people say that, but it's
Well,
pretty
I don't
stressful
know.
when it's
Still
a hearing.
stressful.
It's a hearing.
Yeah.
I mean, it can be lawyered up in a hearing without it being on the record. I really don't, I struggle with this.
I'm
That it's
struggling.
been so challenging for a properly supported district commission to be on the record.
Yeah.
I think I'm worried about forum shopping here.
I think that's a fair question. Jim?
You've heard me say 3-2 wins every time. That assumes an overlay of politics and blah blah, and we're not to assume that. But what it does assume is the vested rights in our district commissions based upon the original concept of mother knows best for her family, is at risk, and which is why I'm talking about this here. So, if the rules changed and it was 3 district commissioners voting and 2 board members voting, then I'm good with having the board shall say this is going to be a major. And because we do want to expedite the process, we do want the majors to go to the board, and for those few appeals that happen to the Supreme Court. Excuse me. This is a huge policy question.
Carrie?
This was a topic of our conversation a week or 2 ago, where we did contemplate in one of the options a different formula board makeup, which we ended up putting aside for what we have in front of us. So for revisiting this question of board makeup, at this time, I think we need to take care in terms of trying to fully understand the implications. I think what I'm hearing is that there is some assumptions, which I don't think is well-founded, assumptions thinking that a professional board is automatically going to rule against a project somewhere in the state that involves district commissioners in that state. I think there are examples when at the district commission level, or depending on that makeup, you could ask whether they are holding in best interest the outcomes we seek for environmental protection through Act 250. Hence why why we're looking at a professional board in the first place, is to ensure that we have the right objectivity and process to ensure that we're making sound decisions that are going to be consequential and meaningful for our protection of our environment. So, and I recognize that, again, I've repeated myself, but this approach of this board makeup with a 3-2 has been part of that joint proposal. It's to strengthen the professionalism of the board process itself, and the full voting equity of the district commission's participation in that is to ensure that, to the best extent possible, we are bringing that local flavor to that decision making. So, with that said, I'm happy with where we are currently, and think that by giving the decision making on major and minor to the district commission, I think we've made important headway into and improving a process is going to, I think, provide for greater clarity, consistency, and compliance with the criteria we lay out in Act 250.
Paul?
You know, it seems like we get further and further away from the idea of place-based decisions, and even down to where we're considering who should make the decision, whether it's major or minor. It seems like that should be place-based above everything else. And I really can't imagine this roving board being that in tune with what particular area or region wants. And and at least if you made it so that the commission had that authority without asking the board, may I, I'm more comfortable that the local voices will be heard. I'm not at all comfortable with the concept anyway, but I mean, this even squeezes it further as far as I'm concerned, as far as local decisions and place-based decisions go. I just don't like the idea of the board having that much power.
So, currently, because the board has the power to decide if something is a major application, how that sometimes plays out is that if no one has requested a hearing, but the board is concerned that there is a novel issue or a novel resource in that area, they can deem it a major application and hold a hearing, because despite the fact that none of the public have raised that issue. So that is another, that's a potentially positive reason that the board has that power. But that's just something to add.
So I've been thinking about this and thinking that we need to add into, and I don't know if this is the right section, but I think it is, a check back in with the legislature on this at a certain time in the future, a report back to us on how this is working and whether or not we need to make adjustments. So I want that to be added into the bill.
I think the NRB has to provide the legislature with a report every year anyway.
Yeah, but I think that report has varied over time and doesn't necessarily include the functioning of evaluating, like, we need an assessment of how many majors were taken on by the new board. You know, I think this may require some different accountability and then also maybe a different check back in with us. I mean, if, I guess the issues are, you know, we've been assured by NRB staff that they will comply with statute and make it work, but we want to hear back and understand where they are in the process and how it's working.
What kind of time frame do you want on that? You want it to be 2 years after the new board has been set up, for 3 years, or 1 year?
2 years sounds good.
Okay.
And with that requirement, I think I can stand down on my concerns here.
And what I heard in testimony on this is that this is language, they already delegate, I think they already use may, and it's already happening. This delegation exists. Is that true?
Delegation to.
Determine major, minor.
So currently it's the commission's responsibility and their authority to determine whether or not something is major or minor.
Oh,
That's
so-
how it works.
And this language says the board may delegate it.
Well, I want to make sure I'm looking in the right place here, because I'm on
Page 8, line 10.
page 8. Hang on here. Right. So, yeah,
They have it anyway.
I mean, currently, it's only the commissions who are able to and authorized to make that decision.
Okay, so I'm okay leaving that
Yeah.
current, let's leave that current. We're still gonna have a check back in 2 years. So you don't have to stand down, Jim, I think we can do both.
So you're gonna change
Language
that
has to change.
the commission, district commission is gonna decide in that line.
District commission will decide major, minor, and it stays the way it happens today.
Alright.
I don't know why we would, I think you're right.
Good. That needs to be rewritten to accommodate that.
The one thing that you might consider, maybe it's already dealt with in this version, is whether or not and to whom that decision is appealed to.
Yep, I thought of that too.
It is, I think it is, and it's probably appealed to the board.
Yep.
Yeah.
So the board is gonna have some say,
Yep.
despite the fact they don't make the original decision.
If someone appeals it,
Right.
Yep.
And there already is a list in our rules of factors that the commissions should be thinking about in making their decision as to whether or not something should be a major or a minor.
okay. All right, moving on.
Nice.
Anything else on this page 8?
Greg, you just mentioned something, you said factors to consider when determining major and minor.
Yeah.
And where are those factors?
So it's our rule, Act 250, Rule 51. and then there's a subsection I could probably get for you in a second if it doesn't have it memorized.
Okay. And the reason why I'm asking is because we've been fundamentally talking about just the declaration of a hearing is what triggers it. But does that have to be the only thing to trigger it? I mean, can you still have a hearing and have a minor? We've been saying no, but maybe there's something more nuanced contained in there that would provide greater direction as to the magnitude of a project is what should be the trigger for determining major, minor versus just whether you have a hearing or not.
Well, one thing is we now have the pre-hearing,
Pre-meeting.
pre-meeting, which actually I think needs to be changed, the pre-meeting, not hearing.
A pre-application meeting or something.
Which may not, I agree with what you're bringing up, and I don't wanna end conversation on it, but I just
Yep,
put
I
out
just wanted
there
to
that
highlight.
there is a pre-meeting, which is gonna be a big difference. Paul?
Well, I'm just wondering in terms of, we've had 50 years now of doing it, basically, you know, whether or not, when a decision is made to go from a minor to a major, how often has that been appealed? We haven't heard that that was a problem.
Seldom.
It hasn't been a contention.
Seldom.
I think I can respond to that. It's relatively infrequent. I would say less than one a year, one every couple of years maybe. There might be an appeal on a decision like that.
And right now, does that go to the environmental court?
Goes to the environmental court.
Okay. All right. So I think the thing that's different now is that the difference between a major and a minor is the hearing process.
That's right.
Yeah.
But for this, under what we're proposing here, it will change significantly, because you'll be bringing in, the board, the professional board to come in. I think that's what we're kind of stumbling around right now, is how does that look? And is there, a role for a hearing in a minor? And I guess I'm thinking that should be, I think that's gonna become clear and addressed in the pre-hearing. I mean, I think that's where that's gonna get vetted.
Do you happen to have Rule 51 open?
I can't.
Oh. I
Do
haven't.
you want to hear the factors?
Yes.
Okay.
Or if
Oh,
Ellen
I
had.
don't
Nope.
know. You got it? Go for it.
Nope, he's
No, I turned to my.
It's on page
our counsel.
775.
Yeah.
I turned to the,
Don't ask me.
We could do a tag team.
I turned to the counsel.
You like
I've done a
Do
lot
that.
of reading today. If,
I'm happy to read
Go
it.
ahead, come on.
All right, so Rule 51A, starting with A1, are sort of the factors to consider. The extent to which potential parties in the district commission have identified issues cognizable under the 10 criteria. 2, whether or not other state permits identified in Rule 19, those are presumptions, are required, and if so, whether those permits have been obtained or will be obtained in a reasonable period of time. 3, the extent to which the project has been reviewed by a municipality pursuant to a bylaw authorized by the statute. 4, the extent to which the district commission is able to draft proposed permit conditions addressing potential areas of concern. And 5, the final criteria, the thoroughness with which the application has addressed each of the 10 criteria.
Thank you.
Sure.
All right, can we keep moving on? Minnie?
Yep.
Well, just, can you tell me where we're at then with it? Is it gonna be the 2 from the professional board sitting with the 3 commissions?
Yeah. No, it's gonna be 3 and 2.
We haven't actually found that section yet to change that language, but
Well,
I'm leaning that, I wanna do that when we get there.
Okay, let's wait till we get there. And this next section is the pre-hearing. Any comments?
I did change
Pre-meeting.
I did change it to meeting.
Thank you.
It's meeting on line 6 on page 9.
yeah, it is.
But in the, maybe pre-application process,
So that's,
line 18, we would add meeting for.
I thought process was
It's in bold.
more holistic.
Encompassing enough, that's fine, okay, let's go. That's great. I'm feeling like I wanna get through.
Page 9,
Yep.
nitpicking, I can't believe I'm doing this.
Can't either.
So thank you.
Line 19, right?
Line 19, yes, exactly. It's either the subsection, this subsection shall not apply to projects or to strike a project. I mean, it's just, right? It should be, it doesn't, it reads really weird, but I leave that to others by just raising it.
Generally, drafting convention is to refer to a singular as opposed to a plural.
A project, so then,
A
It has
project,
to.
okay.
then it shouldn't be a have.
Has, just be has.
Oh, I'm
It's the have
sorry.
or has.
Okay.
Yep, yeah.
Oh, and then remind us what 6025B1 is?
It sets up a procedure by which it can go through a simplified, a streamlined process.
And that's a new one, it's a new procedure.
No.
What's existing?
Yeah. The board may adopt rules to provide for a simplified or less stringent procedure.
Okay. Next page. I have a question on line 15, on page 10. The district commission may authorize the applicant to provide a partial list of adjoining landowners in accordance with board rules. Why is it partial?
So under certain circumstances, the commission might find that the project has no likelihood of impacting adjoiners, maybe on the other end of a 1,000-acre tract.
I see. Okay. I don't need to make an issue of something that's in existing statute, and not an issue, but I just wanted to know. Okay. Page 11. Jim?
Line 16, page 11, I'm betting Ellen would do this, but I'm thinking, since we've given the authority to the district commission, we strike the word board and unstrike district commission.
No? Are you questioning that, Ellen? I can't tell what's,
Yeah, I would not do that.
But we just agreed that the district commission would decide if something was a major or minor, and that would be appealable to the board.
Yep,
Yep.
yep. Oh, and that's what this says?
So this is the board, allowing the board to have something be treated as a major.
Right, and we said they weren't gonna, it was gonna be the district commission was gonna make that decision.
Yeah, we,
By the time it got to them, it'd be resolved, then they would either, if it was appealed, then they would rule on whether or not,
then they would decide.
yeah, but comes to them already decided by the local board, by the commissioners.
Yes. Yeah.
I need to think about it for a second.
Okay.
Sure why. Because right now the district commission has it, and we were gonna switch it, and now we're switching it back to what they have now.
Okay.
The authority to decide major minor. So this is if no member of, no interested parties other than the district commission wants a major, they can say, but we want a major. That's what I think this language is doing.
I have one question about this. We had talked about how the significance of forest block and connected habitat is such that any projects that would encroach upon these finite resources would automatically trigger a major. And I want that as an idea. We heard testimony on that, and thought that was a good idea. We should have hearing on projects that are going to encroach on these finite resources. Would be the reason for why we would trigger that as a major.
I'm not sure. I don't remember the testimony, but I also don't know that that's necessarily true. I mean, if we stand up rules and they meet them, and I don't agree with that.
Okay. That was from the Conservation Law Foundation.
But anyway, can we resolve this, because this is different?
Sure, I can unstrike it.
Okay. Any other thoughts on what Carrie just said among the board, or this committee? I got this.
My point is it's such a consequential, any project that's going to encroach on lands above 2,000 or forest blocks or connected habitat because of their finite nature and irreplaceable nature. We should be throwing all our resources to those.
I guess I feel like they may,
major.
they likely will, especially in the beginning, trigger a major, but I don't know that we need to be that prescriptive. Okay, next page.
I have a question on 12, starting with line 4 on page 12. And it would allow the hearings and the pre-hearing conferences to an alternative location. Well, I guess it's, I'm sorry, it starts on line 3. And I'm afraid if the applicant wants to move it closer to where his base of operations and the board agrees, then we move it out of the place where the project is going to be built or developed. And it seems like another incident of where, once again, we're getting further and further away from local accessibility.
Yeah, so this is interesting because the other section says it will be in the town that I thought the major hearing, this is the meeting.
Mm-hmm.
No, this is the major hearing.
This is the major hearing.
Major
Yeah.
hearing?
One of them, maybe the meeting said it had to be in the town of the application.
Right.
And this one does allow for it not to be, which was my other question about the parties. So if it is to Paul's question, are the parties just the applicant and the board deciding? No, it's anyone with party status.
Yeah.
So they would all have to agree.
Right.
And that's pretty unlikely that they would move it.
Yeah.
They all have to agree.
Okay, that's good. See, I was worried that if it hadn't been, the parties had not yet been defined because there was still a question of whether or not it was going to be a minor or a major.
So this is after that.
All right.
But is party status would be created at pre-hearing conference?
You apply for party status.
At the meeting, at the pre-hearing conference. I'm getting a nod from Greg.
Or at the hearing itself. And so I was gonna point this out, that this,
Okay.
I mean, potentially, this provision could be late for an entity who was wishing to prove up party status at the hearing.
Yeah, okay,
Yeah.
so good. I mean, the only thing I can think is, like, this says the hearing will be in the municipality where the project is located. And sometimes that municipality doesn't have a building with the capacity, which is also in here, that it'll be, that a reasonable facility will be found. And so sometimes those two things could be in conflict. In our neck of the woods, Middlebury might be the only place with an adequate meeting room for the smaller towns around us. I imagine that's the case in other places. So we want it to be flexible, but we don't want people to end up way far away from where the project's being proposed.
Could you
It does
clarify?
say, it's clarified, it says it'll be in the municipality where the project is located.
Well, you could say, if I may, you could just clarify that, saying unless the parties agree to an alternate nearby location or an alternate location of reasonable distance from the project's location, or something like that to qualify it.
And it's also saying that all parties have to agree. It's saying, so if
Yeah.
they wanted to say they, like tree, well, we're gonna have a meeting in Boston. Well, too bad you can't. The parties gonna be like, no, we can go to the next town over, but we're not. So it's not saying that one party can just say we're moving it, to for a 4-hour drive, and we're now going to be, in the Island Pond instead of Middlebury. Well, no. If someone says no, we're not doing that, then it's.
Yeah.
Oh.
I think it's pretty clear.
Then you could just change the not to an all, unless all parties
Unless all
agree.
parties agree.
You can do that.
The question is whether the parties have been identified yet.
Yeah.
Oh, okay.
Yeah.
Not really, yeah.
Can I ask a question? How long does a citizen have to step in and ask for party status when something gets underway?
Oftentimes, under current practice, there might be a petition for party status sometime prior to the hearing.
Mm-hmm.
But oftentimes, that petition won't be made until the first day of hearing.
But that's without the pre-meeting.
That's without the pre-hearing.
I think the pre-meeting is going to really help the public become aware of a potential project, start to understand how they want to be involved in it. I think of all the things that are challenging us in this bill, that's one people agree on.
Well, I'd like to point out in the attempt to expand the dump in Coventry, the folks who finally rallied around and decided they wanted to oppose that expansion came to the hearing very late. And the district commission made a decision, I think maybe the chair, but anyway, I know a decision was made by the district commission to allow them to offer whatever evidence they wanted to put on. And so I'm just kind of, I'd hate to see that lost, that ability to say, no, you weren't here the first day, so too bad.
I don't think it's lost, and I think we have language in here saying, in fact, right on this same page, maximize pro se participation while ensuring fairness. So, I don't know if that's. Yeah. All right, we need to keep going. I feel like this is clear enough.
One way to get to Mr. LaFave's comment would be to, on lines 6 and 7, evidence to maximize pro se participation and ensure fairness of the proceeding. Because the fairness comes with maximizing pro se participation, I would assume.
No, I think there is this, not necessarily, so striking the balance, because you have to have, you don't want to prejudice an applicant by allowing, there should be some flexibility so that, if the pro se neighbors who wanna come and introduce evidence against the landfill are late, there's some flexibility, but Act 50 has a general policy that parties should be in the process as early as possible so that the developer or the applicant has notice and ability to respond, so that there isn't objections coming too far down the timeline of the process.
Right. Someone walking in on the last day and saying, I want to be a party. No. Okay.
So it's fairness to both the pro se as well as the applicant.
Okay.
Thank you.
Are we okay with this the way it is? Getting a sense of no.
Yeah, no, I'll think about it.
Okay. Next page.
This is annoying, okay, but I'm gonna just ask this. For the notice, is anybody contemplating rulemaking so that so that more than just a newspaper notice goes out? Like, you know, so it's not in the green books, but it is more than a newspaper, because we've heard testimony, but not this year, but in the past biennium, about people, oh, well, we had no idea. So, I mean, you've got anything, rules where you could put things on Front Porch Forum and put a sign out or something?
Will you add on page 12 the board's website?
That's not good enough. I'm sorry to say this. But who in the world goes to the board's website who's just a regular old person? Nobody. I wouldn't even know how to do that. So I think it should be something that's really known by neighbors.
The neighbors have gotten notice.
All right, more than just the neighbors.
They've gotten a letter.
Why? Yeah, but people don't always open their mail. I wonder if we could send to rulemaking something that could be more creative and more insistent.
Front Porch Forum, fake news. Just saying.
Mine isn't.
So, are you familiar with A&R's new process where on their website you can sign up to receive alerts about permits?
Well, that's great, but I'm just a regular person. There's something going on. I'm not totally paying attention because I'm working a job, my spouse is working a job, I've got childcare problems, I've got a lot of problems. And now, all of a sudden, there's something that might be happening, it's in a letter that I don't happen to open yet because I pay bills only once a month.
So I just
real
want, I
stuff.
do want to point out that there's municipal permitting, and planning commission are going to review an Act 250 development proposal, and there is also the notice of affected adjacent landowner. There are multiple ways that projects become aware of projects. And now with the pre-hearing, the regional, I think with the regional planning commissions and, I think this comes up with every land use application. I mean, it's a challenge, but we have a lot of rulemaking in here already. Do you hear from people who are surprised? Greg?
Yeah, I'm trying to think. I mean, we hear from people who allege that they've been surprised, and sometimes it's difficult to. So there's a provision in our application that requires, number one, an adjoiners list, so that those adjoiners could be noticed by writing. There's also a provision in our application that requires any other interested parties to be indicated who they are on the application, so they also can be noticed. But frankly, sometimes it's difficult for an applicant, I imagine, to make that determination in the first instance. There might be some obvious circumstances where the applicant knows, oh, so-and-so isn't an adjoiner, but he or she might in some way be affected by this permit application. So a provision can be made for those other interested parties, but as a general matter, I'd say we don't often hear about notice problems.
I know we need to finish it, but I remember testimony from the first biennium that I was here, and I think it had to do with the up there, the
The dump.
the dump. And it was all about, we didn't know, we finally figured it out, then we
Yeah.
tried to get together. It was a lot of testimony.
You're right.
If you're, if you're getting a letter, what else would you recommend?
Well, if you went to rulemaking, you might figure out some creative things. So that'd be my opinion. I'm just expressing my opinion.
It's fine.
I would like to convince you that I think that it's worth doing something about.
Jim?
For me, not here, not now. Thank you very much. It's awesome.
Okay, let's keep going. Trying to get through people's questions, so I'd like to keep going a little longer. How are folks feeling on the next page?
That would be 13.
Yes, 13.
Good. 14.
I heard 13. Ben, did I hear 14?
Not saying 15.
No, not for me.
Anything on 14?
Oh, yes. It's a policy decision. Lines 1 through 5. Yeah. Oh, maybe even more. It's about hearing officers. Do we want to have hearing officers? What we've heard they may expedite the process, is what we're trying to do. But we've also heard, I think, pretty strong citizen concerns that hearing officers are not well loved in the system. And so we're creating here another structure in the ill-loved puck. And I'm suggesting we don't want hearing officers.
Karen?
As someone who was a hearing officer and a utilities analyst, energy analyst for the state, I felt well loved. But it was really about just management of workload. The hearing officer still reports to the board and does the board's work. It's almost like the ghostwriter, the hearing officer for the case. The board is the one that signs the decision. And so I see this as just a tool in the toolbox that doesn't have to be used every time. It's often typically an employee. In this case, it was an employee of the commission, and it helps with just case management.
Paul?
And I'm with Jim on this one. I think, a hearing officer, a lot of times his decision can be overturned by those above him. So you've had this evidence permitted, you've had hearing, and all of a sudden he makes a decision, and that happened in the case of East Mountain. And as far as the PUC goes, the hearing officer heard that entire case and decided no, it shouldn't go there, and the board overturned him and ruled on it. Still refused to give the permit, but on an entirely different matter, because the developer would not go through a series of tests with birds in terms of flights. And so I think the hearing officer, is minor maybe, I don't know, but I hate to think of a hearing officer having that much power. That's all. and then not really having power when it comes down to it if they don't agree with it. So, I'd get rid of it.
Jim?
Notwithstanding our need to press on, we have lost Matt's voice and Lee's voice, and this is a policy decision. They are available to us today and would likely be available after the floor. I'm not one to shut off conversation about this, but maybe delay a decision.
Sure. I think that's right.
Yeah.
Yep, all right, I'm hearing you. Let's recess for lunch.